We'll hear argument this morning in Case 06856, LaRue versus the Wolfberg and Associates. Mr. Stris.
Thank you, Mr. Chief Justice, and may it please the Court. Let me begin with the first question on which this Court has granted certiorari. Sections 502A2 and 409 of ERISA permit restoration of, quote, any losses to the plan.
What are the code numbers of those? I really get confused. You people who work with ERISA all the time can refer to, Section 3 of ERISA. I use the code. What code sections are you talking about?
I never thought the day would come, Justice Scalia, when I was described as working with ERISA all of the time, but I will tell you the code provision. The code provision is, for 502A2 of ERISA, is 29 U.S.C. 1132A2. It's found on page 10A of the blue brief.
Good.
Section 409 of ERISA is 29 U.S.C. 1109. And I was quoting specifically from 1109A, and that is found on page 9A of the blue brief.
Thank you.
Now, the statute plainly states that, quote, any losses to the plan, unquote, may be recovered if they were caused by fiduciary breach. Our position on the A2 question is straightforward. The plain meaning of any losses to the plan includes any diminution in value of defined contribution plan assets, regardless of the number of participants ultimately affected.
But the plan itself is nowhere in the record, is that right?
Well, the summary plan description was attached to the complaint.
Right, the summary. And I looked at the summary and saw nowhere the rules about investment options, what you get to choose, how often. And for all we know, the plan might say you have no choice about investment options. It's all going to be invested in T-bills or whatever.
Respectfully, Mr. Chief Justice, that's not true. I would point your attention to page 19A of the appendix to the brief in opposition. And this is the page of the summary plan description that makes clear that participants in the plan, like Mr. LaRue, will have the opportunity to direct their investments.
But that wasn't in the record.
That is in the record.
It is in the record.
Yes. And to be clear, Justice Scalia.
Where in the record is it?
It is page 19A of the.
No, that's in the opposition to certiorari, and I don't believe that that's in the record.
Oh, it is in the record. It was attached to the complaint that was filed by Mr. LaRue in this case.
Oh, that's the summary of the plan.
The summary plan description, that's correct. And as you know, Mr. Chief Justice, if there's a conflict between the summary plan description and the summary plan description governs. It's a legitimate document.
The summary on the page you mentioned says that you will be able to — you have certain investment choices are available to you, and that the administrator will provide you with information on what they are and how you can change it.
That is correct.
Well, we don't know those details, correct?
That's true, but this case was decided at the pleading stage. And so, to be clear, we alleged that the right given to Mr. LaRue under the plan was violated. If true, then that would constitute a fiduciary breach.
It would also, presumably, more obviously, constitute a breach of the plan, correct?
Which, yes, that's correct, and that is a fiduciary breach. Under 404A1D, failure to act in accordance with the terms of the plan is a classic example of a breach of fiduciary duty.
So your position is anything that is remediable under, if that's a word, under A1, it can also be pursued under A2?
No, that is not my position.
Let me step back. Do you agree that you could bring an action under A1 for this breach of the plan?
I think that's far from clear, but what is clear is that we could not recover what we wanted under A1. A1 only permits a lawsuit against the plan. Here, the plan doesn't have the funds that are
where does it say that A1 is available only against the plan?
The specific language of A1 doesn't state that. It states that you can get benefits due under the plan, or you can enforce your rights under the plan. I'm not aware of a single case, Justice Ginsburg, where an A1B action has been permitted to recover personally from a fiduciary. That is the purpose of A2, which specifically states that you can personally recover from a fiduciary.
That's fine. So why doesn't he proceed first under A1B against the plan?
Well,
because the plan owes him this money, and if the plan turns around and says, well, the fiduciary didn't invest your funds the way it was supposed to, the plan still owes him the money, doesn't it?
I think the answer to that, I think there are two reasons why that's incorrect. And the first reason is 502A2, unlike 502A3, is not a catch-all provision. So if he has a remedy under 502A2,
No, I'm talking about A1B.
Right, and there's nothing to suggest that that provision is mutually exclusive with another provision. So my first response to your question, Justice Scalia, is that even if he could have proceeded under A1B,